Good evening, everyone, and welcome to this evening's webinar. This is primarily for Defence members and families. So the information will be aimed at the differences that that community faces, but otherwise it's all still relevant for anyone else who chooses to listen. So tonight we're following on from a webinar we did recently, which was wills and guardian appointments, and now we're filling in the rest of the estate planning information for you with superannuation and powers of attorney. Who am I? My name is Jackie Broman. I'm the principal solicitor at TBA Law. We've been running TBA Law for 10 years. My primary practice area is wills and estates. You can see this logo down here, the circle thing. I am an accredited specialist in wills and estates. So as well as having done my law degree and 15 plus years practice, I also went ahead and did an applied master's degree in wills and estates. And then after that, did another 12 months with the Law Institute of Victoria to get the accredited specialisation. So you do a deep dive program while working, of course, and a big exam at the end. Not a whole lot of people pass that. The failure rate is higher than 50%, but that's why the knowledge and being able to express and transfer that knowledge is very valuable. And as a bit of a indication, there's about 22,000 lawyers in Victoria, and there's only 80 of us with this accreditation. I also won an award in 2019 for Regional Lawyer of the Year with the Law Institute of Victoria. So that was a bit of a pinnacle. I am also a defence spouse. So we've been lucky enough to be posted in Victoria for 10 years and at various different locations, of course, but I've been able to continue to run my practice from there. I have been with my husband for over 20 years. So we have had a number of postings to other interstate locations as well, and certainly been through a number of deployments and other things that defence members experience. So estate planning in 2022 is very different from what it might have been, for example, 70 years ago in the 50s, or even in the 80s, 40 years ago. It's no longer just a will. Those horrible little wills that defence members get from the defence lawyer really do not cut it. And not only that, of course, it's quite often done without the spouse. And so the spouse may either not have a will or not have a mirror image will or not hear the advice. And so it's a bizarre situation, really, that a defence lawyer would do a will for a defence member and not consider the family. But other than a will as well, when you're doing your estate planning, you do need to think about property ownership, particularly when defence members may be accumulating property and then meet someone later. And of course, then potentially how they move forward investing together. How many assets do they have that are jointly owned versus individually owned? Tax is far more complex than it's ever been, and we do have to consider what the impact of tax is on your estate plan. Superannuation, which we're talking in depth about tonight, is not generally covered by your will, but it is quite often one of the biggest assets that someone has. And so how do we make sure it gets to the right person that it needs to get to? We're obviously living a lot longer as well. So whereas someone may have been lucky to have 10 years in retirement, now you're more likely to have 30 years in retirement. So we need to make sure we've got enough to see us through, but that then also has impacts on our declining health through our retirement. Powers of attorney, there are various types, which we're going to talk about. And quite often we're talking about the powers of attorney that are in place for an emergency. So if you've lost capacity, who's going to do things for you? Who's going to make decisions about your kids? Who's going to keep the bills paid? Who's going to access your super if need be? Healthcare directives, so that you have directions for your medical powers of attorney or even directly for your healthcare providers. Trusts are more often used these days than ever, whether you have a trust for doing investments in. Superannuation is a form of trust, but also if you have children who are under 18, you will be setting up a form of minors trust in your will because your kids can't inherit until they're after 18 anyway. 18 is often quite too young, so we quite often extend that minors trust out until a child is older. And then there's other various forms of trust that we can access and utilise as well, depending on a beneficiary's needs. And if there is a disabled beneficiary, of course, that's quite important to make sure that we don't impact any benefits that they might otherwise get. Guardianship, I've touched on. So if you have minor children, you do actually need to specify who needs to care for them. If you've gone, it is a legal appointment. So it happens in the will. It's not your godparents that you appoint for your kids. And of course, thinking about what happens if you have a major injury and become disabled, or then, of course, as well, aging and then maybe no longer being able to stay at home, what the impact of that will be on your assets and your family. So all of this is included in estate planning. So into super. Now, as I said before, your will does not cover your super. So superannuation is a special form of asset. As you're probably aware, it's highly regulated. We can't access it until we reach a certain age, depending on where we're born and all those things. Defence super is also has different categories and so is quite different compared to many other industries. So the older form of defence super, DFRDB, is a purely defined benefit. They did phase this out in the late 90s, and then so newer members have MSBS, which is a combination of defined benefit and accumulation. And then for newer members, you have straight accumulation, which is very similar to every other industry. So it's been brought in line. Back when it was DFRDB, it was quite common for government employees to have this form of super, and it can be quite good if someone is going to live for a long time after retirement, because regardless of what you pay into it, you get a set pension for the rest of your life once you're retired. But of course, when they first set up DFRDB, they were expecting someone to only live for 10 years into retirement. So it became far more expensive when people were living for 30 years. So that is partly why they phased it out. Certainly for other public services, it was phased out for that reason, because it was not viable. So the difference then is with DFRDB is because it's a defined pension, it means that there's no lump sum. So if someone passes away and they have a spouse, the spouse gets 5/8 of the pension. And if there's kids under 18, they get a small benefit as well. But once the kids reach 18 or finish study, they don't get a pension anymore. And there is no lump sum for the spouse. So if you passed away and there was still a mortgage, there is no lump sum to pay the mortgage out. Your spouse just gets that dwindled pension for life, for their life. So yes, there's some benefits, but there's also benefits for lump sum, particularly for those who still have debt and don't have life insurance as well. Whereas the MSBS has a accumulation component where a member has contributed, so the member's benefit can be paid out as a lump sum. And then there's the defined pension component as well. And then more recently, the purely accumulation form where it's all member benefits. It can be taken in either form. So it can be taken as a lump sum or as pension or vice versa. So you can take a proportion as lump sum and then keep some as pension. But coming down to everything, so those are the three main types that a defence member may have of super. Who can actually benefit from your super? So we've spoken about DFRDB before. As a defined benefit, only your spouse benefits from that. There is no lump sum. So if your spouse predeceases you and then you pass away, there's nothing for your kids. Your MSBS does. So the accumulated lump sum component can be paid to a beneficiary other than your spouse. So there is a lump sum that can be paid out even if your spouse has passed. And then the accumulation form is like every other form of super. And the beneficiaries that you're allowed to pay your super to are either a spouse or your children or someone who's financially dependent on you. So the beneficiaries that can actually get your super are very narrow. Those are the only categories that you can pay super directly to. So if you wanted to pay your superannuation, so thinking of a young member, they may try and nominate their parents on their superannuation. That would be an invalid nomination and the super fund would not pay the super to the parents. The super fund would make their own decision from there. And we don't want the super fund making their own decision. We want to have that control. Another member may want to pay their superannuation partly between their siblings and their parents. Again, none of those are financially dependent people, and so any nomination to those people would also be invalid. So we do have to be aware of who the beneficiaries are that can benefit from super. There is a way around that, and that's part of the estate planning process, because the only other form of beneficiary is that you can direct your super fund to pay any lump sum into your estate. In which case, then your will needs to think about what happens to your super. So you actually put something in your will about it if that's your decision. And how do you do that? Well, you do that with a binding nomination. So DFRDB does not need a binding nomination because you don't have a choice. It goes to a spouse if you have a spouse left, but otherwise there's no one else who can get that. Although the super fund does need to know who your spouse is. So for those who separate but don't divorce, you've got to be really clear with your super fund whether you've got a spouse or not. And particularly if you get a new spouse, make sure that's updated. Because after you've separated, you probably don't want your life pension going to your ex. For all the other forms of super, there will be a binding nomination that you can download from their website. This is for any industry fund as well. You can download the specific binding nomination for your fund from their website. They don't come out with your annual statements, although when you do sign up for a super fund, quite often they send you a pack with the binding nomination in it. So quite often people have done it at least once. However, I find that they've more often than not done it incorrectly and nominated someone who can't be a beneficiary. But that being said, even if they did it the first time, on most of these forms, it does say in really little writing that it expires every 3 years. So then if you don't keep doing it every 3 years, it expires, and then back to the super fund making the decision for you. So you do have to be quite careful. On some of the forms, you can actually say that the nomination does not lapse, but certainly on the newer type of super for younger members in defence, it's just the same as an industry fund otherwise, and they all only take a binding nomination for 3 years. So what do you do? Well, I tell people to try and do it every 2 years. 3 years is an odd number. I don't know why it's 3. The legal industry is actively campaigning the superannuation industry to try and change it, but they don't care. They often don't even tell people that they need to do a binding nomination. So yeah, I tell people every 2 years because you do it when you do your tax return. So just get it in your brain that when you do your tax return, you do your binding nomination. And if you remember doing it last year, then you don't have to do it. You got a year off, and then you do it the next year, because sometimes years go really quickly, like it has in 2022. And you're like, oh, I think I did it last year. Yeah, I think I did it last year, so I won't do it this year. But in fact, you probably did it in 2020. But at least then you're still within the 3 years. So try and aim for every 2. So binding nomination. For it to be binding, it has to be witnessed by 2 witnesses, just like a will. So you have to sign it with 2 people present. They both need to sign it, and then it's binding. If you do it in any other form, it is not binding. So again, a lot of super funds allow you to log in online and put in a nomination, but it is not a binding nomination. It is a non-binding nomination, which means the super fund can ignore it and do whatever they want and make their own decision. So, what I was going to say, and should before I move on too much into types of powers of attorney, is some of the decisions I've seen super funds make when there's no binding nomination. So where a single person has passed away, separated from their spouse, decided not to pay it to the ex-spouse, which was a good thing, decided to pay it to the 7-year-old daughter. However, they obviously the daughter can't have it till she's 18. So they contacted the ex-spouse, and the ex-spouse set up a trust and put it all in the trust for the child, which ends at 18. However, in his will, he had his parents looking after the money for his daughter, and the daughter not getting it until she was 25. So that was his preference. He didn't have many other assets other than his super. So the parents ended up looking after, I don't know, $50,000, $60,000 or something like that. And the wife ended up looking after $300,000, which the daughter got at 18 and promptly wasted. So that's an example. Another example I've seen often is the separation issue. So someone has separated but not divorced, has passed away, and then the entire super is paid to the ex. Or otherwise, I've also seen where the super fund decides not to pay it to a spouse or children, but instead pay it into the estate under the will, which has it open to claims. So sometimes that works fine, but other times when there's a potential claim through a will and the super fund forms part of the estate, it just makes it a bigger pot for more money to be paid out on a claim, unfortunately. So there's some things to think about with your super. Now on to powers of attorney. So there's 3 main types of powers of attorney: enduring, general, and medical. The general one is the one that I do want defence members to think about, particularly for deployment or longer courses, or, you know, long look or something like that. A general power of attorney gives someone the power to do something specific for you while you're away. Or you can specify the actual thing they can do under what condition they can do it. Most often it has to be under your direction, even though you're absent from the jurisdiction. But then it also ends after either a period of time or if a certain circumstance is no longer in play. So a general one is really important, and I do not believe that members get that advice sufficiently before they are deployed, certainly not given out by defence lawyers. The enduring power of attorney is generally what we do as part of the estate plan. So an enduring power of attorney is called enduring because it lasts, or it endures past you losing capacity, which is the point of it. So you can have it begin immediately. So for example, you could use an enduring power of attorney in place of a general one and give your spouse an enduring power of attorney to begin immediately. They just can't use it without your specific direction while you have mental capacity. So we do that quite regularly. But then after you've lost capacity, that person can do whatever they need to do in your best interests. The other thing to think about with an enduring power of attorney is your children. So in that situation where you've given your enduring power of attorney to a spouse and you have young children, your spouse can get a bit stuck because she's only supposed to act in your best interests. However, there's best interests of her and as a family as a whole, as well as your kids. So what we do to get around that in the powers of attorney we prepare is put a clause in to say that your attorney is allowed to use funds to maintain your dependents. So again, thinking about the circumstances and the families that we prepare these documents for, certainly for defence members who generally have young families, that's really important. Whereas if you do a standard form, it'll be silent on that, and then your family could get stuck. A medical power of attorney sort of speaks for itself. It's for someone to make medical decisions for you if you can't, if you're still alive but cannot give your doctor instructions. So again, you probably appoint your spouse or someone at home. And so the difficulty is, in the case of an emergency, the doctors are going to do what they're going to do to keep you alive, which is probably what you want anyway. But then it's when the doctors have stabilized you and they go to your family to, ask for decisions to be made, you have at least one person who can actually make decisions. Your next of kin can do it to a degree without having a power of attorney. However, they can't refuse medical treatment. They have to pretty much go along with the guidance of a doctor. Whereas a medical power of attorney can refuse treatment if that's your wishes in a certain situation. For a medical power of attorney, you can only have one person at a time, but you can have multiple people named. So you could have, for example, 3 or 4 people, but they're in a cascading order. With an enduring power of attorney, just like a will, you can have 4 attorneys or 4 executors in a will, and then you can also have 4 alternates. And so then what you need to think about is, if you have multiple attorneys, whether they have to act jointly, whether they can act separately, whether they have to act jointly for certain assets and otherwise can act separately, or whether they have to act by majority. So then you can think about how you want that to work. So some decisions to make around powers of attorney and superannuation. Instructions to attorneys. So this one, particularly if it's a general power of attorney and for example, you've been deployed and you want a certain amount of your earnings to be invested in a certain way, which you can probably do online now anyway, or perhaps you want real estate bought while you're away, or you're halfway through buying something and you want them to finish it. You have specific instructions actually set out about what they are to do and in what circumstance. Other instructions you might think about could be under an enduring power of attorney in terms of what's important to you to keep maintaining. Certainly in terms of dependence, you want certain gifts to be made, certain charities to benefit, those sorts of things. When does a power of attorney begin? So I've briefly touched on that as well. So a general power of attorney would begin in the specific condition that you would say. With an enduring power of attorney, you can have it begin immediately. You can have it begin immediately with conditions. You can have it begin on a triggering event, or you can have it begin when there's a medical certificate issued to say that you can no longer make decisions for yourself. So have a think about when you would want such a power to begin. Single or multiple people, so I've touched on this as well. So you can only have a single person at any time on a medical power of attorney, but you can have multiple people in the enduring power of attorney or a general power of attorney. And then if you have multiple, how do you want them making decisions? Jointly, separately, or as in severally, it's a legal term, or by majority. And if you do want them to act jointly, for example, and they actually can't come to a unanimous decision, you could have some process of a dispute resolution built in. You could have one person with a veto power. And same with by majority, you need to think about if you have the same three people, are two always going to gang up on the third? So some kind of process you can think about there as well. So that's the main content. And back to what estate planning involves in 2022, which was our second slide. This little poker chip sort of has all the elements that is included in a family legacy plan that we do for someone. So we look at property ownership and how you own property and whether the ownership needs to be changed or whether there needs to be specific acknowledgements of who's contributed what. And so property can be directed in a certain way. If you don't want to leave everything to your spouse, for example, you can have a life interest over something and then leave the whole bulk of it to someone else. It just gives us some more flexibility. We need an understanding of who owns what and how it's owned. Wills, of course. We've spoken about enduring power of attorney. Medical decision makers is your medical power of attorney. Advanced healthcare directives go hand in hand with a medical power of attorney. So a medical attorney is supposed to act in accordance with your wishes and values. But how do they know that? Well, if it's someone that you speak to regularly about it, they'll know it. And so you don't necessarily need those wishes and values written down. But if you want absolutely no doubt about what your wishes and values are, then you can put it in an advanced healthcare directive. We've spoken about a binding nomination on your super fund tonight. We've spoken briefly about what a trust would be back at the start. A testamentary trust is a trust that's created under a will. If you have young children, a trust will automatically be created because they can't get their money until they're 18. But we can look at other forms of trusts, particularly if you have a disabled child or you want to protect it long term rather than just 18 or 25 or so forth. So we can do some fairly interesting things with the inheritance that way. Life insurance is certainly something to think about, which I touched on briefly when we were talking about DFRDB and total and permanent disability insurance. These are not built into defence superannuation like it is into other industries because defence members do have Veterans Affairs and medical cover. However, thinking about whether a lump sum is needed or not, particularly with your level of debt, can be very important. Instructions to guardians can be important if you have young children and it sits behind a will with details in it about what medical care is important for your children, who their doctors are, what extracurricular activities are important to them or that you want them to participate in, how you want them to learn about pocket money, other things that you just want passed on to your children as well. Family trust. So for those who have a family trust already set up before they pass away for their investments, for example, family trust holds property and it doesn't form part of your estate. So we need to make sure that the control of the family trust goes to the right people so that those assets actually go to who you want them to go to as well. your personal stuff, you may have instructions about that, and you may also have memorial instructions. So all these things are included in a family legacy plan that we do with TBA Law, and the cost is not prohibitive. If you're worried about what the cost might be, it's under $1,500 for a standard one for a couple. A couple gets a discount, and defence members get another 10% off as well. And the process is not hugely scary either, so it doesn't take long. We guide you through the process. We send you some initial information so you can prepare some things. But if you don't prepare them, that's fine. In the first appointment, that's our information gathering. We know what questions to ask to guide you through to help you make your decisions. Between the first and second appointments, we draft what needs to be drafted. We email you those drafts to have a look at. We finalise those drafts via email. If there's any information you didn't have at the first appointment, you can get it back to us by email and we can include that in the drafts. The final drafts are then presented to you in the second appointment and we sign everything. This whole thing can also be done via Zoom because we can sign remotely as well. And then after you've signed everything, we finalise some things. We make sure the super nomination is lodged. We make sure that your attorneys have accepted their appointments, and then we deliver you the final documents, certified copies if you like, electronic copies if you like. We generally hold on to the originals because we have a strong room and we provide that service for free, but you're quite welcome to the originals as well. So that whole process takes between 2 and 3 weeks. So you can have it over and done with before Christmas and not have to worry about it before your new posting. So thank you for listening. The website here is a special website on our web page for Australian Defence members. There is a link there where you can start the process online of your estate plan. If that's easier for you, start gathering the information and putting your thoughts together. It also confirms the 10% discount, so make sure you do mention that, because if you don't mention where you came from, we will conveniently not offer it. So you do have to say you're a defence member, and then you're eligible for that. So you're quite welcome to contact me on the same website, tbalaw.com.au, meet the team. My direct email is there. You're quite welcome to ask me any questions that you have. And I'm now going to go to Q&A as well. So those of you who watch the recording, please reach out via email, and happy to guide you in the right direction and provide you more information if you need.